Welcome friends. I am Advocate Amol Samant from Kudal, Sindhudurga. Today is the 11th webinar lecture and resource person is Advocate Raju Poulekar, who is very good friend of mine and having command over narcotics law. Friends, as we all know, our Bar Council member Honorable Advocate Sangram Desai has put a lot of effort for this webinar series in this lockdown period for the benefit of all the advocates, especially from Sindhudurga, Ratnagiri, Goa, Mumbai, Kolhapur, Sangli, Satara, and so on. Today, Advocate Sangram Desai is busy in some other important work. Hence, as per his instructions, I became host for today's webinar. Till today, renowned persons had delivered lecture through this series and many more to come in coming period. Like tomorrow, Advocate Nimbalkar from Sawantwadi will be interacting with us on the topic of will. Then day after tomorrow, Advocate Khandeparkar, senior lawyer from Mumbai, will be handling topic of Rain Control Act. On 22nd, Advocate Viresh Naik from Kankauli on the topic of Section 65B. On 24, Honorable Kiran Bagi Sahib, Registrar High Court at Goa, will be interacting us with on the topic of basic principles of evidence. So I request Advocate Abhay Chiklikar please to introduce Advocate Raju Poulekar. Thank you. Over to you,
Yes,
Abhay.
yes, sir. Good evening, everyone. I have the pleasure today to welcome Advocate Kamlakan Poulekar, who's also very commonly and very most popularly known as Advocate Raju Poulekar. He completed his law degree in the year 1999 from Salgaonkar Law College from Miramar, Goa. He grew under the guidance of Advocate Jose Peter D'Souza since 2000, and till date has accumulated experience over 20 years in the criminal practice and more specifically in the NDPS Act. He is also well known for conducting trials uh, in other states like Maharashtra, Karnataka, Kerala, and Rajasthan and Hyderabad as well, from JMFC level to High Court level. Advocate Poulekar is also known for his contribution in the cases which had caught a serious attention of the national and international media, like the Scarlet killing case, Goa police drug nexus case, as well as the Fab India case. So I would request Advocate Raju sir to kindly continue with the lecture. Thank you.
Good afternoon, everyone. Big namaste to everyone, all the participants here. It's my honor and privilege to be part of this webinar, wherein I've been asked to present a topic called search and seizure under NDPS Act. First of all, I'd like to thank the President, Vice President, Chairman, and all other members of Maharashtra and Goa Bar Association. Also, a special thanks to Mr. Advocate Sangram Desai, Advocate Amol Savan, and Advocate Abhay Chiklikar for coordinating this program with me. So let's begin with this topic called search and seizure under NDPS Act. Prior to that, I think so I'll be failing in a duty if I don't thank my guru, my mentor, my boss, my senior, Advocate Jose Peter D'Souza, and Advocate Caroline Colasso, under whom I've learned the tricks of this law under NDPS Act. So let's begin with the seminar and this lecture. The law, NDPS law, came or evolved in 1985. Now, prior to this, there was a act called OPM Act 1857, and Opium Act 1878. There was also a Dangerous Drugs Act 1930. Now, in 80s, this person called Richard Nixon in US all of a sudden waged a war against drugs because he felt that lot of drugs were coming from Mexico into US, and a lot of these Mexican immigrants were consuming and controlling the entire drug trade. So lot of pressure was built in 80s on all the countries uh, to come up with a strict law, the stricter punishment or stringent procedures and punishment on the NDPS law. And therefore, in 1985, India enacted this law called NDPS Act, which deals with controlling, prevention, prohibition, consumption, possession, sale, export, import, all almost you can name any activity under the sun, and it is prohibited under NDPS law or drug related laws. Now, so with hello, I'm audible. Yes.
Yes, yes.
So yes, yes. Okay, all. So this so the act came into existence wherein the major changes or major amendment were brought in this act in 1988, 2001, and 2014. Now, in 2001, the entire act was divided into three categories. That is a small quantity, variable quantity, and commercial quantity. Now, prior to that, there was no small quantity. So, if a person is caught with drugs, even a small quantity, then he had to go in a witness box and prove that it is for his personal consumption. And then he was awarded a lesser sentence. Otherwise, a sentence under the earlier act before 2001 was almost 10 years. So, in this category now, in 2001, they made three categories, that is small quantity, commercial quantity, and variable quantity. The entire there are almost 256 or 236 substances or drugs which are prohibited or banned in India under the act, and it is recorded in the table of the NDPS. Now, if you look at this table under NDPS Act, it will give you serial number. There are six columns: serial number, drug name, uh, non-proprietary name of this drug, then the chemical name, then column number 5 and column number 6 will give you what is the small quantity. So there is a figure. For example, case of charas. If person is caught with charas, the small quantity for charas is 100 grams, and the commercial quantity for charas is 1000 grams. That is 1 kilo. Same way, if a person is arrested for the possession of cocaine, then the small quantity for cocaine is 2 grams, and commercial quantity is 100 grams. 100 grams, yes. For heroin, it is 5 grams, and commercial quantity is 250 grams. For LSD, it is 0.002, a small quantity, and a commercial quantity is 0.1. So these are the few substances which are banned, and I took the name of these few substances because major raids in India is conducted with respect to these substances. But altogether, there are many other substances, and the list is given under that table. Now, what is the small quantity and what is meaning of a commercial quantity? Any quantity which is lesser than what is specified in that table is called small quantity. For example, as I said, charas. If you look at charas in the table column 5, it is shown as 100 gram. Now 100 gram will not be exactly a small quantity. In order to qualify to be a small quantity, it should be 99 grams, or it can be 99.99, because the definition under NDPS Act of small quantities lesser than quantity lesser than what is specified in column number 5. In same way, for the commercial quantity, it will be greater than what is specified in column number 6 of that table. That example of a charas, now charas 1 kilo. So in order to qualify to be a commercial quantity, it has to be 1.1 kilo. If it is 1 kilo exactly, it won't be qualified as a commercial quantity. It can be still called a non-commercial quantity. So these are the two main definitions of small quantity and commercial quantity. Let's look at the other definitions. I will take you through some of the definitions. Now, the anti-act, as the name suggests, the act says it's narcotic drugs and psychotropic substance. Now, what is narcotic drugs? Narcotics drugs are more like a natural drugs or comes from basically nature, which include cannabis, which include opium, which include coca leaf. Narcotics drugs definition also include manufactured drugs. In same way, the definition of psychotropic substance, it says that a drug which is specified in the schedule, there is a schedule given under NDPS Act. They are altogether 111 substances or drugs which are prohibited, and it is listed in the schedule and which are called as a psychotropic substance. So psychotropic substance is a substance which goes through a chemical process, or it is a synthetic or more chemical drug which is called a psychotropic substance. The other definitions on the act, like related to, let's take related to narcotic act only. Basically, cannabis. Now, cannabis or hemp or charas is being defined under NDPS Act. Under cannabis, there are 3 clauses. First, what is charas, what is ganja, and the mixture. Now, all 3 will qualify to be cannabis. Now, charas means it is derived from a cannabis plant. There's a plant called cannabis plant, which is mostly grown in hilly areas of North India. If you go anytime to Simla or Himachal Pradesh, and lot of these plants grow as weed. You can see these plants even on the road being grown. So from the cannabis plant, 3 things are derived. That is charas, ganja, and uh, bhang. Charas is banned or prohibited under Cannabis Act or this Act. Ganja is also prohibited under NDPS Act, but bhang is not prohibited because charas is a separated resin of this cannabis plant, whereas ganja is a flowering top or fruiting tops of this ganja of this cannabis plant. And bhang, bhang is derived from mostly the leaves. Like in India, mostly during Holi, like this mixture is prepared and then people consume this drink or shake or bhang shake it is called, or bhang tea also it is called. So basically the bhang will not come under NDPS Act as it is done prepared from the leaves, because from the definition of ganja, leaves and seeds are excluded. Another definition is about coca plant, coca leaf. Now this is also prohibited in India. Mostly the coca plant is not grown in India. It is grown more in Mexico and that region. There is no also history that this plant is grown in India. Coca leaf, the leaf of the plant will be a narcotic drug. But the final product, which is prepared from this plant, then that product is called cocaine. And the cocaine is a psychotropic substance because it goes through a chemical process in order to become eventually a conclusive substance, and therefore it is termed as cocaine. Same way, opium. Now, opium also is a narcotic drug. Now, opium is mostly found in the states of Rajasthan, state of Madhya Pradesh. They are, it's cultivated they are allowed to cultivate by holding a license, this plant. Now, if you this we use something called khaskhas in Indian cuisine. Khaskhas is nothing but the opium seeds. Opium seeds are not prohibited under the act, but rest of the plant, that is the entire plant, is called poppy straw, and the coagulated juice which is removed from this fruit. If you see this plant, it's like a ball type of a fruit which will come on this plant, and you remove the juice from it. There's a process to remove the juice of this plant. This plant is called opium plant, and the juice which is removed from this fruit will be called as opium. From opium plant, you also derive morphine, heroin, diacetaminophen. All this is extracted from the opium plant. So these are the three major plants which will come under NDPS Act. So there are some other definitions also which are also important, like addict. Addict also is defined under NDPS Act. Addict is a person who has a dependency on drugs, or who consumes drugs. There is also definition of preparation in the NDPS Act. A preparation means when the two drugs uh, are mixed together, then the mixture is called preparation. But both the drugs should be prohibited under NDPS Act. Then only it will qualify to become a preparation under NDPS Act. Next is a definition called illicit trafficking. Trafficking into the trade of narcotics. In the trafficking, if you check the definition of trafficking under NDPS Act, it is wide. Everything is covered under that. Possession is covered, cultivation is covered, manufacturing is covered, production is covered, uh, selling is covered. So anything under the sun, all the activities which are prohibited are covered under this definition. So this was a few definition which is important if you are trying to practice on the NDPS side. This you need to remember this, because this will come very handy on a everyday life of a defense lawyer. So let's look next is basically the real topic of today, that is search and seizure under NDPS Act, and which are the agencies and which are the officers who can actually conduct this search, seizure, arrest under NDPS Act. Section 42 of NDPS Act deals with, which is mandatory, with the officers who can conduct a raid under NDPS Act. Any officer of a central government or state government above the level of peon, sepoy, or constable is qualified to be an officer who can conduct a search and seizure and make arrest under NDPS Act. This section 42 is divided into two subsections, subsection 1 and subsection 2. Now, subsection 2 states that when any officer receives the information, he has to reduce that information in writing and then send it to a immediate superior officer within 72 hours. And this is mandatory. If this is not done, then you can even claim acquittal or your bail only on this aspect of the case. The first section deals with basically who are the empowered officers. The central government by special or general order appoint the empowered officers not below the rank of sepoy, constable, or peon of both this agency, and they have been given power to make arrest, search, seize without warrant. Remember, this 42 deals with without warrant. So there is no need of warrant in the first part. So they can go and seize any document if the accused does not allow them to enter the place or building, then they can break open the lock and then enter, forcefully enter and conduct a search, seizure and arrest. Also seize any property which is derived from the proceeds of illegal trade. Also seize any other documents or anything, relatively anything which will provide as a evidence in the NDPS case or NDPS trial. But there are two provisos to this. Here, the first proviso is basically when a manufacturing unit or a licensed manufacturing unit is raided, then it has to be the officer above PSI level. So the head constable and ASI will not be allowed under this provision. And the second proviso is if the officer want to conduct a raid after sunset and before sunrise. So he will have to write his reasons. He has to write, record the reasons why he is going for such raid and raid the place in the night. So this is the crux of section 42. Now, whatever is stated in section 42 is in addition to what is stated in CRPC. There are a lot of provisions in CRPC with respect to search, seizure, warrant, arrest, rights of the accused. And these sections are basically from section 40 to 60, 71 to 81, 165, 100, 93. All these sections deals with the issue with respect to the search, seizure, and arrest, and which are also important because there's a specific section in the NDPS Act that is called Section 51. Now, 51 says that if Section 51 says that if whatever stated in CRPC with respect to warrant, search, and seizure is not consistent with the uh, Section 42 or NDPS Act, then it will come or it will have application. Means basically the CRPC will be applicable. All the sections of CRPC which are stated will be applicable if it is not inconsistent with the NDPS law. And there's a specific section that is, I said, section 51 of. Now let's look at a practical aspect of actually what exactly the police or what exactly the other agencies do, or how they conduct a search, how they conduct a seizure, or how they make arrests under NDPS Act. I will divide this section in two categories again. There are police officers and there are central officers. Police officers is a police. They can be a regular police, they can be anti-narcotic cell, they can be crime branch or any other police in any other state. And as far as the central agencies are concerned, they are Customs, Narcotic Control Bureau, DRI, that is Director of Revenue Intelligence, then Central Excise, all are allowed under the NDPS Act to conduct search and seizure. Now let's look at the practical aspect of police. What kind of cases police will conduct? Mostly police will conduct small cases involving a smaller quantity or variable quantity or a commercial quantity. And every police station, if you check, every police station will have their own format. And the format goes like this. They will say that, yes, at 9 o'clock, I received the information that Mr. X is going to come to deliver the drugs to his customer or prospective customer at football ground, so and so. He'll be coming on a motorcycle. He'll be wearing this particular type of clothes. Then they arrange pancha witnesses. They arrange a kit box. They arrange a seal which to be taken for the raid. They arrange an entire raiding party and then they leave for the raid from the police station. They will even tell you that, look, this person sat at this place in a jeep or somebody came with a motorcycle. They went on a spot of the raid. They waited there for the accused to come, and fortunately, accused come exactly at the same time which they believe accused should come. If it is set at 12 o'clock, accused will reach on the spot exactly at 12 as per their records. So once the accused is apprehended, they run to they first identify him, they run towards him, they circle him, and then they introduce themselves to the accused. So accused will tell his name and address and father's name and all other details. And eventually they will tell the accused that he has a right to take his search before gazetted officer or magistrate, and then start searching him. They will search, they will find drug in his right hand side pocket, and they will recover this drug from him, pack and seal the drug. They will conduct the entire panchanama. They will record a seizure report. They will prepare something called a forwarding note. A forwarding note is a note which will be sent to the chemical analyst later. And then eventually they will part with the seal of the police station, which is used in the raid, to some other officer, or like mostly it is DYSP. Now this is the pattern followed by police. At least in Goa, this is a pattern. You can check any police station, and most probably this you will find only this kind of pattern used by the police. The another pattern is perhaps which I have seen in the other part of India. Mostly it is called chance recovery. Police, they conduct a chance recovery where they are waiting on the naka, and all of a sudden two people come in a motorcycle. They are stopped, and on seeing police they start to run. They run in the bushes, so police run after them, and then police catch them, and then they find drugs on them. So this is the style. So if you check each and every police station will have their own pattern, their own template or own style. And even the officers will also have their own style of investigation or conducting this search and seizures. This was respect to the police officers. Mostly police officers will do a smaller cases, not a bigger cases like the other counterparts, that is the central agencies. So let's go to another agency called customs. Now customs which basically will conduct raids on an airport. A person traveling abroad, a person coming in, comes with drugs. Either his personal search is taken and uh, drugs are seized, or most probably when the drug or the bag or his luggage goes to this X-ray machine, the X-ray machine will identify that he's carrying a particular type of drug. So once they will identify, they will get pancha, they will conduct a seizure, pack and seal, then they will issue a notice under section 67 of NDPS Act to this officer, to this accused, and tell him to make a statement before them that how he procured this drug and in what manner. So the statement is recorded in writing, where most probably the first two pages of a statement will only say that where he was born, who was his uh, uh, parents, and where he studied, to show that this whatever is written there is within the knowledge of this accused, and accused only has made this statement. And it goes then eventually to the raid, how the raid is conducted, and from the where the drug is procured. Now this is a very important aspect which I will take in detail little later, that is section 67. But this statement recorded by these custom officers will be admissible in evidence. Statement recorded by NCB officers, statement recorded by DRI are admissible in evidence, because these officers are not police officers. Like if police officer record a statement that it is prohibited or it is barred, it is not admissible under CRPC. So since these people or these officers are not uh, this police officers, the statement recorded will be admissible in evidence. The next will be NCB. Now, NCB also follows. Now, NCB will conduct more bigger raids, like 20 kilos, 30 kilos, uh, that kind of substances. But the process followed by NCB is also same as like customs or the police, except for recording of a statement of the accused, which will be admissible. The next agency will be DRI. Now, DRI style of DRI or revenue intelligence is they would conduct raids interstate mostly. One time they will raid a factory in Mumbai. The same time they will raid another factory in Goa or Hyderabad that way. So they basically do a much bigger seizure which have international links or connection. So, but pattern again remains the same on this seizures. Now, let's look next. So once this is done, once you know that these are the officers who can conduct raid, what will be a next challenge to you? Like what as a defense lawyer, once you come to know that mostly people will always call you in night, because most of this drug raid happens in the night after sunset. So you as a defense lawyer be ready to keep your phone next to your pillow. That's the life of a defense lawyer. So what are the exact challenges which a lawyer faces when he's dealing with the NDPS search and seizures? Let's say the raid is conducted, or somebody after sunset calls you saying that my son has been arrested for possession of drugs and he has been taken by the police. So immediately what you should do is you should try to check which police it is, try to find out under what provisions of the NDPS Act the person has been arrested, what quantity has been seized. Now, every lawyer will not get this information, believe me. The police, when you are defense lawyer for the accused in a drug case, police are your enemy. Almost everybody is your enemy. You will not get a free and easily, and nobody will give a information, because you will try to contact a police officer or a particular police station. The phone will be off the hook. The raiding party members phone uh, will be switched off. So per se ab initio, you will never get this information quickly. So once you don't get this information quickly, next step for you would be like going to that police station. So you with your client or their family member have to visit to the police station, wait there for the circle inspector or PI to come and give you the information. If he gives you the information, then it's fine. Then immediately your job is to apply for FIR copy, Panchanama copy, and seizure report. These are the three documents which you can get easily if you make application. But once you make an application, they can say that no, I will not give you this copy. If you want, you go and claim it from the magistrate, or you claim it from wherever you want. But he is not giving you any document. So next step is going before the magistrate, seeking or making an application for your client that you need a FIR copy, Panchanama, and the seizure report. Now, why this? Because FIR copy will give you exactly the entire detail, what exactly has happened on a spot, or details of a raid. So you have a fair idea what are the allegations against you. Then if you are entitled for FIR copy, because FIR is a public document and therefore it has to be given to you. Same way, under section 100 of CRPC, Panchanama copy also has to be given, but it is in an enclosed place. The section 100 of CRPC says that any raid is conducted in an enclosed place, then the officer has to give a copy of Panchanama to the accused. Now, this was respect to the police, how they would go about when a raid is conducted, and what will be your job, how you will react to this raid. Your job will be much more difficult when it comes to central agencies, because remember, most of the central agencies will not have a particular station or particular lockup in the place. They usually camp somewhere and then conduct a raid. So it will be difficult to find out which are the officers who actually came and picked up your accused, whether it was customs, whether it was NCB, whether it was DRI. And neither you will have any connection or phone numbers of this officer to contact them immediately to ask them any information. So in absence of this information, you can try to contact a local police station, try to see if they have any information that any search raid is conducted in their area. If they have, then you can ask them which are the agency or who are the people who came actually and arrested this accused. So let's say they say no, it is not this police station, it is not ANC, it is not crime branch, but it was Narcotics Control Bureau, that is NCB. So the moment you know, you will have to try again to contact them, same way like police. You will not get information. So you then go to this or to their office wherever they are camping. Now, when you arrive there, you will see, at least we have faced this problem many times in Goa, where NCB office is closed and we are made to wait outside almost for hour with the uh, person, and sometimes they don't allow also to meet the accused. Now in that case, if they don't allow you to meet the accused, now accused has right to contact his lawyer, accused has right to contact his best friend or family. So your job is to again approach magistrate in that area or jurisdiction and tell him that you went there, the place is closed, we are not allowed to meet. So allow us to meet the accused, as I want to seek instructions from the accused with respect to his arrest and detention. So if it is allowed for possession, of course, possession of the drugs. So once it is allowed, you go and meet the accused with the order of the magistrate. Now you will see in these cases, mostly central agencies, like many a times handcuffs are used, many a times they are beaten and assaulted, and many a times, and this is all done to take or record that statement under section 67 of NDPS Act. Now section 67 of NDPS Act says that these agencies can call for the information from the accused with respect to activity relating to the drugs which is found in the possession with. So therefore, they collect this information via 67 statement. Now, so once you meet this accused, I would suggest that you can have a lawyer can prepare a template, or a lawyer can prepare a questionnaire for the accused. Like it can start with the name of the accused, address, age, his other details, and then actually what happened. Now, questions like what time was you picked up, from where were you picked up, how many officers came there, how many officers were in a civil dress, how many officers were in a mufti uniform, then whether any offer was given to this accused in order to take him before the gazetted officer or magistrate, that or any offer was given to him to search the raiding party, whether indeed they packed and sealed the drugs in presence of pancha or presence of the accused, whether any panchanama was prepared, whether any seizure report was prepared, whether any other property like a passport, cash, uh, then gold ornaments, watches, mobile phones were taken from the accused. These details is extremely important to defend your client, because sometimes this minute details can seek you acquittal in the NDPS cases. I always tell the officers here that NDPS case is simple as having a, especially possession case, having a pen in your pocket. The officers only have to prove that the accused was carrying this pen in his pocket. The accused was carrying this drugs in the pocket. As easy as that for them. So this details is important, and these details will be more and more important for you in the cases of NCB, customs, and DRI, central excise also, because they will record that statement. So you need to ask each and every detail. Suppose after the raid is conducted, what exactly happened? Where was he taken? Whether he was taken directly to their station or office, whether he was taken to medical and then brought back to the station, whether he was served any notice under section 67, whether he was handcuffed, whether he was beaten up. If yes, then beaten up, what kind of beating, what kind of, on which part he was assaulted, whether he was threatened uh, to shoot, because mostly they will keep the gun and all on table and try to investigate these offenses, whether he was threatened that his family members would be arrested if you don't make a statement. So these are the important factor. Reason being, you need to retract this statement. If a statement is recorded under 67 by these agencies, then you will have to file something called a retraction of this statement uh, under 67. Now, the retraction can come as a special application before the court, or it can be also incorporated in the bail application. What do you want to say? So a statement, when they record this statement, you will always see a statement will start as that I am so and so residing so and so. I am giving this statement out of my free will, not under pressure, not under duress, not under any assault. So remember this word, and also remember many a times a style which is followed by these agencies. Sometimes they will write this statement. The NCB or whoever these officers are, they will write this statement. Sometimes they will record a statement, type it on a computer and give it to you to write in your own handwriting. Sometimes they will write a statement in a question answer form, and your signatures are obtained mostly on all the pages. They will also make some correction in between. They will also ask you to put an initial, uh, your initial, because to make this statement more and more genuine. So whenever a magistrate looks at the statement, we will say like, look, you have signed this statement, and you have signed every page. You have signed also the mistakes you have done and initial this. So to give the authenticity to this statement, this ideas or creativity is used by the officer. So you have to be very specific in dealing with these cases and seeking instructions. Write each and every minute details which accused tells you. So once that is done, you file the retraction before the court. Once the retraction is filed, at least you are sure or aware that uh, this may not be used, because this is done in first point of time before the court. So immediately after the arrest, you retract. Now, for example, let's say by following all this process, this officer never allow you to meet the accused. Then remember that within 24 hours, this accused will come before the court. Keep a watch there. When accused is come before the body are brought before the court, request the magistrate that you want to talk to him, and then take these instructions. And if he is assaulted by these officers, then you will have to complain to the magistrate. You have to tell the magistrate that yes, he has been assaulted by these officers. he need to be sent to an independent doctor for medical examination and report to be called. And if there is any injury found on this accused, then a magistrate itself has a right to conduct an inquiry under CRPC to know how this injuries was caused to the accused. So this will be the instructions. So once you have all these instructions from your client, what will be your next step? Next step will be going back to your office perhaps and looking at the provisions for which your accused is charged. Now mostly the accused will be charged, if it's a possession case, he will be charged under section 20, 21, 22. Now three sections of NDPS Act which are important for purpose of punishment, uh, and it is there in chapter 4 of NDPS Act. So section 20 says that when any person, section 20 of NDPS Act is divided into again two categories. The first part, 20, section 20, clause A, deals with the cultivation of cannabis. So when any person cultivates cannabis plant, he can be punished and sentenced up to 10 years. Then the second category, that is section 20B 2I, capital A, capital B, and capital C, deals with possession, uh, production, selling, uh, warehousing, producing of the drugs or cannabis. A deals with a small quantity. As I said earlier, small quantity means quantity which is recorded in column number 5. So the punishment for a small quantity is 1 year, and fine is basically 10,000. Similar way, punishment for intermediate quantity or a variable quantity is up to 10 years and fine up to 1 lakh. For commercial quantity, the sentence is 10 years minimum, which can go up to 20 years, and minimum fine of rupees 1 lakh, and which can go up to maximum 20 years. Now, this was respect to section 20 cannabis. Same way again, section 22 deals with psychotropic substance. Again, it is divided into the same categories: small quantity, variable quantity, and commercial quantity. The punishments are almost same. Section 21 deals with manufactured drugs. Again, same is divided, section is divided into three categories: small quantity, variable quantity, and commercial quantity. And punishment is same. Now, more important, the more major sections, other major sections are section 19 of NDPS Act, section 24 of NDPS Act, section 27 of NDPS Act. Section 19 of NDPS Act deals with the embezzlement of the opium when opium is produced and a theft is committed, or it is the entire cultivation is misappropriated. Then the minimum punishment for that offense is up to no minimum is 10 years, and it can go to maximum 20 years with the same fine. Same way, section 24 again deals with international trade. If a person sitting in India conducting an international trade in a drugs or psychotropic substance, then he can be charged with the offense of same of punishable with minimum 10 years, maximum 20 years. The last is 27A. Now 27A deals with harboring of the accused and financing the illegal trafficking trade. Now, under this section, everything, almost everything, if you read that section or definition of illicit trade, everything, entire activity under the sun is prohibited or banned, which is related to the drugs. So financing and harboring will be a offense and sentence will be again 10 years. So once you are aware of the sections, most probably they are altogether many sections there, uh, but I am just taking the few because I want to shift to the other aspect quickly. So once you know these sections, once you realize you have met the accused, you have come to your office now, you have studied why, under what provisions he is charged. Next step definitely for you would be you want to file a bail application for him. So if you want to file a bail application for him, you would want to know where you should file a bail application. For that purpose, I will deal with section 36. I will deal with section 36A, subclause 36, yeah, subclause A and 36D. Now, 36 section 36 says that where the that every area should have one special court where the offense has taken place. Now, special court is meant by a special judge. A special judge under NDPS code will under NDP in the NDPS code will deal with NDPS matter, and there will be special PP. So that three special thing: a special court, special PP, and special uh, judge. These are the three people who will be dealing with NDPS cases. Now, Section 36A says that if the special court can deal with the offenses which are punishable above 3 years. So, any offense which are punishable below 3 years will go automatically to JMFC, Judicial Magistrate First Class. Although the NDPS Act is silent about it, but for this purpose, you will have to look into a second schedule of CRPC, wherein when offense is punishable with 3 year sentence, then magistrate would have power, and that offense will be a bailable offense. So anything below 3 year will go to JMFC court. Anything, any offense which are punishable above 3 years will go before only special court. Now, there will be a possibility, there will be a possibility that the in the area there may be no special court constituted. So then there's in 36D there's a transitional powers. If the special courts are not designated, then the session court will have power to deal with the NDPS cases. Was in a transition process. So whichever area, if there is no special court, then it will be the NDPS sessions court. Now, I will relate to one incident. Actually, we were Aparian in Oris in this case, and I was against Mr. Amul Savan in that case. I remember that case because it was the first time I went to Oris to defend the accused. This accused, he was a German national arrested at Savantawadi, and they found some charas. They claim the NCB officers claim that they found charas from him, and they were taking him for remand before additional sessions court in Oris. So the remand was taken all the time before additional sessions court in Oris, and he was detained under the said remand orders. So when I went there, I checked whether this additional sessions court has been given power or delegated the powers of special court, and I found that there were no such powers delegated to him. So he was not a special judge under NDPS Act, which is a requirement of Section 36. So immediately I told my boss, and boss said, like, file a bail application immediately, claiming that one sentence, that present detention of the accused is illegal, unwarranted, and not as per the procedures of NDPS Act. So the bail was filed in the Sessions Court, not before the Additional Sessions Court, claiming that my detention was illegal. And after going through, reply was filed, and they also came to know at that point of time that there was no such order, or there was no such special or general order or notification appointing the additional session judge as a NDPS judge under section 36. And they judge session judge granted bail to us. Now there were two accused. So immediately what happened, once I got a bail for this particular accused, the second accused approached us and told us that no, like, I also want to engage you, let's file bail for me. But by then, what the NCB officers did was, NCB officers started producing the accused before the session judge, who had power to remand him. So all that custody, the moment he was produced before uh, special the session judge, his custody became legal, and we could not file a bail application, because by the time we could go and file, his custody had already become legal, and we knew that he will not get bail on that particular point. So these are the things which uh, will come, because, and this is what something which you'll have to research. You have to go on a scene of offense, you have to go to the court, find out about all these aspects. Then once we deal with, or once we know which are the courts which will take up our matters, then next step is immediately prepare a bail application and file the bail application in the court which has a jurisdiction to deal with it. Now, with respect to, as I already said, there are three quantities: small, variable, and commercial quantity. Now, with respect to small quantity, your bail will go to JMFC. It's a bailable offense. So even under 436 of CRPC, you can claim your bail from the police. But police in the drug cases mostly will not grant you bail. So eventually you will have to land up before JMFC and say, please grant me bail. It's a bailable offense and no conditions to be imposed. Even if a person is a foreigner, the JMFC cannot impose any condition in a bailable offense. Second is variable quantity. In a variable quantity, since the offense is punishable with up to 10 years, it will go to a special court, and the constraint of section 37. Now, 37 of the NDPS Act deals with the bail under NDPS law or under NDPS Act. 37 says that before the bail application is heard by the special judge, he has to give a notice to PP to oppose such bail application. And if PP opposes, the public prosecutor opposes such bail application, then accused need to show that there are reasonable grounds to believe that he is not guilty of offenses under section 19, 24, 27, and possession of drugs for commercial quantity. And this is very important aspect with respect to these three sections plus commercial quantity, because usually it is extremely difficult. It's not easy to show that reasonable grounds to believe. What is reasonable grounds to believe? Reasonable grounds to believe means something more than prima facie ground. Now, this section 37 is very draconian law, because if you see CRPC or even IPC, even in a murder case, you will have a bail. You will get bail perhaps. But in the drug cases, there is a clear embargo, there are clear restraint against you that no, you will not get a bail in a commercial quantity or under section 19, 24, and 27A unless and until you are able to show that there are reasonable grounds to believe that you are not guilty for such offenses, and you will not commit the said offenses again. So what could be this reasonable grounds? I'm here since a bail is always important aspect for every defense lawyer, because he can earn little more on the bail application. Let's look a little more detail with respect to this bail. Now, when I say if you want to show to the court that reasonable grounds to believe that he's not guilty, you can show it in two ways. One, if there is no compliance of mandatory provisions of NDPS Act, like section 50, like section 42, if these are not complied with, since you by now you have a FIR, in the FIR you can check whether after receiving the information they have sent this information to the immediate super officer. If the raid is conducted in your place or your private room or house. So if this is not there, this is a very good opportunity and very good ground for you to claim your bail on this for non-compliance of this section. Again, section 50. If 50, I will come to this 50. 50 says basically that accused has to be, whenever they want to search, any empowered officer want to search the accused for drugs, then accused has to be told that he has a right to take his search before gazetted officer or magistrate. And if he says that yes, he want to take his search, then either he should be taken before the magistrate, or a magistrate or gazetted officer has to be brought on the spot of the raid, and in present the search has to be made. If magistrate or gazetted officer before him is bought, accused is bought, if he feels that there's no need to search, he accused can magistrate can discharge the accused totally. Then no female member, no female accused can be searched in presence of a male member or by a male member. But there is another clause there, that is clause 5 under section 50, which says that if officers can take a search of the accused even after giving this offer under section 50, provided that if such search is not taken, then he will part away with drugs, part away with drugs. So then, so these are the main grounds, but I will go to the facts now. These are on law. Law facts basically will be like simple. I remember one case which my senior handled here. Like a person was, a foreigner was arrested in a room in 101. Now the case against him was that the officers received the information. They went to conduct a raid. They conducted a raid in room 101, and they found around 30 or 20 kilos of charas in that room, and they arrest the accused, and then they file a charge sheet. Now when we saw the charge sheet, in the charge sheet there was one document of the hotel or the hotel register, which said that room number 102 was booked by the accused and not 101. So for all purpose, it was room number 102 which was in possession of the accused, or they could only establish a link with room number 102 and not 101. So therefore, on this ground, of actual ground, the bail was granted to the accused. The other factors which you can use is if the weight of the drugs is taken with the polythene bag, then there is no confirmatory weight of the substance, that to show that it is a commercial quantity. Now, recently, you must be aware also that there is a recent judgment, a judgment of Mohanlal, which says that IO and complainant should not be one of the same person. That can be also a ground under the NDPS Act to seek your bail. So there are other such grounds which can be taken in a commercial quantity way, and it is not impossible. It is difficult, of course it is difficult, but it's not impossible to get a bail in the NDPS. Now suppose, let's say by chance that like you're not successful, you're not able to get the bail, and when you file, so your next chance will come after, if I'm talking about only commercial quantity, this section 36 again A, which says that the officers have to complete the investigation within 180 days. If they do not complete the investigation within 180 days from the first remand, then they will have to make an application before a special judge to extend the time of investigation. And when they make application, the accused need to be intimated, and accused can file a reply to such application, and uh, bail then the time for the investigation will be extended. Now this will be a very golden opportunity if you are dealing especially with the NDPS Act. Please see that you have a diary, you write down on which day the accused was arrested and which day accused was first time produced in the court for remand. Your 180 days will start from the first remand. So you calculate 180 days. When it is 180, people think or lawyers think that it is 6 months. It is not 6 months. So you'll have to calculate literally 180 days. The moment 180 days gets over, next day, even maybe in the night, you will have to go to the judge's place and say, look, 180 days are over. At 12.1 hour, my custody is illegal. Give me bail. And you will be entitled. There is a lot of guarantee on this kind of default. It's called default bail. It is same provision like what you have in a CRPC, where the charge sheet has to be filed within 60 days and 90 days, depending upon the punishment of offense. So the same provisions are there also here. Now, but the 60 days and 90 days are converted into 180 days. Now, this is in relation to the other acts like TADA, I think so, MCOCA, and where more acts dealing with the national security. So these provisions are there in the this act. This is called a default bail. Now, for purpose of variable quantity, where the punishment is not minimum 10 years or which is extended up to only 10 years. Now that 180 days will be not applicable in such cases. What will be applicable is 60 days. So the moment your 60 days get over, you file a bail wherever special court or you can go to high court for that purpose, and there is a kind of a guarantee. So once this is done, your bail is done. Eventually, the police will complete the investigation and file a charge sheet in the court, or the agencies like DRI and NCB, they don't file charge sheet, they file something called complaint case, which is there in CRPC. So they will file a complaint against the police. A charge sheet will have Panchanama copy, statements of the witnesses, and the most important document charge sheet will have is the CA report, the chemical analysis report, stating that the drug was sent to him, he checked the drugs, and it is a prohibited substance under NDPS Act. This is very important document. Remember, this is absolutely important document. Even the case to be lodged, if the CA says that it is not a prohibited substance under NDPS Act, the police or the central agencies cannot even file the charge sheet in the court or complaint in the court. Now, once you look at this, you will also see again in a complaint case also will have a Panchanama copy, seizure report, statement of witnesses, and the statement of the accused. So even if you're prior to the charge sheet, if you have not done the retraction, the moment a complaint copy is given to you, you will have to file a retraction, because now there's a copy of the statement of the accused in the complaint. So you have to file immediately retraction of this offense. How do we defend the accused in the NDPS cases? This against the search and seizures made by all these agencies. Now, I will say that there are two categories again here. You can raise the defenses which are already available under NDPS Act. It is there in a book. And the moment you read the charge sheet, you will come to know that mandatory provisions of 42, section 50 is not complied with. And therefore, this perhaps a bit easy case, or you'll be able to seek acquittal in these cases. Only mandatory provisions. Okay. Now, then The other category is basically most important category, that is defenses which the lawyer for the accused will raise. And he, for that purpose, he will have to research, he will have to visit the scene of offense, he will have to depend upon his juniors to conduct a very good research. He has to manage his office, how to go about defending this accused in uh, these cases. With the law again, as I said, 40 to 50. 50 are two main sections which you can claim your acquittal. Now, let's say that a raid is conducted in a house of Mr. X and they have found a drugs. A client will always ask you this question. Remember that can police, can this officer come and just raid my house without a warrant, without a authorization? Yes, under 42 is it is allowed. Under 42, under section 42, it is allowed, but between sunrise and sunset. Now, there is a provision under 41 of NDPS Act, which says that power of magistrate to issue warrant and authorization. Magistrate, the empowered magistrate, that is the metropolitan magistrate, first magistrate of first class, magistrate of second class, or any other magistrate empowered by central government can issue a warrant to conduct a search in any place for a purpose of seizure of drug. And same powers under that section 41, section subsection 2, also same powers are also given to the gazetted officer of the state and the central government. So when this provision is there, that warrant has to be secured and then the raid has to be conducted, the very next provision 42 says that no requirement. It says that power to seize, search, arrest without warrant. Now, so what is the difference between these two? If the raid is conducted in your house without warrant, then it is the job of the accused here in the facts of the case, job of the advocate to claim prejudice. How prejudice is caused to the accused in this case for conducting a raid in his house without a warrant. For example, let's say a police officer says that he received the information at 9 o'clock that drugs will be found in the house of Mr. X at 5 o'clock. And directly 5 o'clock he comes and seizes the drugs without warrant. Now, if you see the time span here, the time span is from 9 o'clock morning to 5 o'clock in the evening. So there is lot of time for him. He can go to the magistrate, he can go to his own gazetted officer of his department or any other gazetted officer and get warrant and then come and search. So you claim in a cross examination or you develop in a cross examination of these witnesses that there was a good time spent for you to comply with the section 41, but for obvious reasons that you have not done it, so therefore this entire raid is suspect and cannot be believed. So this is the job of the lawyer when it comes to the cases where the compliance, strict compliance is not required, but those provisions are there. And as I said earlier, in CRPC also, there are a lot of these provisions for search. You can take all these defenses with respect to the NDPS cases. Let's look at another defense in this case. As I said, 50, I said, look, let's go a little bit on facts. If, for example, complainant, I took one more. Okay, I will case laws in that basically how you define. I will. We had this very interesting case at MAPSA. We were defending. My senior was defending. It was a case of a Czech Republic who was arrested for drugs at particular place, and the case was that the ANC receives the information. They come to raid at 5 o'clock near one football ground with one jeep number 100, and they wait for the accused to come. The accused comes there, accused is searched, and the seizure of the charas is made from it, which is commercial quantity. So we didn't get bail for him, but eventually this matter came up for trial. And in this case, the witnesses were excellent, like Pancha witness, the other all the witnesses. We could not penetrate with any of these witnesses. And I remember I was sitting next to my senior, Mr. Joseph D'Souza, and conducting uh, a cross examination where he had planned a cross examination of this witness, and he started cross examination of this witness, and still we were not able to penetrate through him. But at the end, a few questions were asked on a station diary, and he was asked to produce a station diary of the case, and he produced a station diary. The moment my senior looked at the station diary, he found a point there, and all of a sudden he changed his cross examination from a very slow pace. He became like a Dhoni who comes and hits sixes and eventually wins the game for India. So his cross examination was started like this. I remember this. Like, you say that he was asking to this officer, you say that you came in this Mahindra jeep bearing number 100, and you left the police station at 9 o'clock, and you reached the spot at 10 o'clock, and you waited in the jeep. The accused came, accused was searched. When you packed and sealed these drugs, where did you keep these drugs? Where it was kept on the ground or jeep? He said it was kept on a jeep. So whether any light was used, he said yes, the light was used on a jeep. He said that he also asked him, did you write the Panchanama on the jeep or bonnet of the jeep? He said, yes, we wrote the Panchanama on the bonnet of the jeep. And then eventually, means multiple, more than I remember, more than 15 to 20 questions were only on this jeep bearing 100, which was there on the spot according to the police. And then eventually he said, please look at the entry number so and so in your station diary. The jeep number 100 is taken by another officer at 8:30 in totally different direction and is gone there. And there is no entry that he has come back till 9 o'clock. So eventually it was argued in the case that if he says that everything on a jeep, their own documents, own station diaries says that the jeep was not even available for them to travel from the police station to the place of the raid, and we got acquittal only on this point. Another see, so you'll have to look at various documents which they may not provide you in a charge sheet. Remember, they will not provide anything which goes against them. You I think so. Advocate Sangram Desai, basically, when he gave his session, he mentioned this all the documents like a logbook of the vehicle, station diary entries, then uh, jail register, the lockup register. So all these documents will give you the additional point or additional clues how to defend a accused in a search and seizure matter. One more interesting, I remember this case also, one more interesting case where it was somewhere in 2008 or 2009, like this anti-narcotics cell conducted nothing less than around 20 cases. And in all 20 cases, we were defending the accused, different accused. But the common factor in this cases was a pancha witness. A same pancha witness was used by the officers in all the cases. So when we were cross-examining this pancha witness in every case, we started asking him the question. Yes, you have acted as a pancha in this case, that case, and he agreed. So we was able to establish that the said person is a stock witness. of the police, and he's available. So this witnesses, the Pancha witnesses, has to be independent witness under section of 100 of CRPC, and it's very important, especially for the drug case, because remember, in a drug case, you will have witnesses, all the witnesses who are raiding party members, who are police officers, except for this man who is so-called independent witness. But interesting dialogue which happened with this witness was in the cross-examination. We were asking him question with respect to that he has acted as a pancha witnesses in all these cases, and he agreed to it. But and when we put a suggestion, that we always put suggestion like this, that you are a stock witness of this police station, and therefore you have signed the pancha panchanama at the police station. To that he answered that, sir, if I am a stock pancha witness, you are a stock advocate, because in all these 19 cases, same advocate was appearing against the same pancha witness. This is what we call a courtroom drama, and something which I really remember. And this was like more than 15 years back, but I remember his words and the humor around this. But this is the way. But this was easy case. Perhaps he was admitting that he was a pancha witness. But remember, in the cases, a pancha witness can come and he may not admit. He may not admit. There, this is where you will have to use your man management, your juniors to do research, because my senior always used to tell me, go to different offices of a criminal lawyers, find and research about the different pancha witnesses, and make a list which pancha witness has appeared in which cases. So we used to make a list. So this all depends upon a research. If a pancha witness comes and witness box, he says, no, I am not a stock witness, then you can always show that, look, you have acted as a pancha 5 years back, 2 years back, and I have a document to it. You can contradict him with that document. That will make the entire evidence of this pancha witness doubtful, or maybe even not even admissible under the law. So this is the way you would do uh, a research and get through in the drug cases. With respect to pancha witness, I remember also when this we came up with this cross of a stock witness, they change the police change the style or pattern. They started getting a government witnesses or government employees as a pancha witnesses in most of the raid. Now, once they did that, we realized that, remember, when a government officer or government servant comes to act as a pancha witness, there is something called a roster which a government officer has to sign at the workplace, and that roster has to sign for morning, then lunchtime, then 2:30, and when he leaves the office. And most of the this employees will sign that. So if you are able to get that document, get it in advance once you realize that so and so person is a pancha witness, and then check on a day of the raid whether indeed this person was in office or he was taken for the raid. If he has signed 4 times on a day of the raid, well, definitely he has not gone for the raid. Perhaps he is called later and asked to sign the panchanama at the police station, and he has signed under his maybe superior person in the office has told him, go and sign the, because they mostly use peon and that kind of persons to sign this. So these are the defenses which you can raise in the NDPS act. Now I think so. How much time left here? Uh, okay, I will take one more. I think so. My 5 minutes are left. So one more case I will take is of a very interesting case again. I remember this with respect to lockup register. A person was arrested under information. Let's say between uh, let's say between 7 to 9 o'clock in the night, and then he was taken to, on particular day, he was taken to the police station, and then the charge sheet was filed. Now, accused told me that no such raid was conducted between 7 to 9, but he was arrested and picked up much earlier to, that is around 2 o'clock in the afternoon time. And then he was put in a lockup. So, what we got is basically lockup register. Lockup register didn't show anything. Lockup register didn't show that he was put in a lockup between 2 to 7, since the raid was from 7 to 9 and he's brought back to police station much later. So there was no entry. But interestingly, there was some other document which actually provides meal for the person who are lodged in the lockup. Like, they have to be given breakfast, they have to be given lunch, they have to be given tea at around 4 o'clock, and then a dinner, the 4 slots. And in that document, there was entry wherein it was shown that a tea was served at 4 o'clock to this accused in the lockup. Which, so once I was able to show the code that, look, that by 4 o'clock, if I'm in the lockup of this police station, there cannot be a raid somewhere else between 7 to 9, where I am found with drugs and they caught me and then they found cheras on me. So these are the things. This will come only by way of research. One more interesting case, which is not a NDPS case, but why I am want to stretch on this is because of reason that how you can actually cross-examine the expert witness in these cases. If you want to examine, if you cross-examine the expert, always remember, prepare and go. Make preparation. You have to be sure about yourself, what you are asking. Otherwise, you can get a damaging answers. Now, this was a case of dacoity where 5 people enter the room with the mask, with the gun. They shoot from this katta, local katta, and the bullet goes and sits in the drawer. And they commit robbery there. They take all the gold ornaments, and eventually they are arrested on the railway station, wherein gold ornaments and the this gun is found with them. So police were trying to link, because there were no identification since they were wearing masks. The police were trying to link this accused with the gun which was found with them and the bullet which was found in the room in that drawer. So we wanted to conduct a cross examination of the ballistic expert who had given a report stating that yes, the bullet found in this room is the bullet which is fired from this particular gun. And that time I remember one of my colleague, Advocate Don, he was helping because he was very good in ballistics and he knew everything about ballistics. So we made lot of homework, lot of study on this ballistics issue, and went to cross-examine this witness. So when we were conducting this cross-examination of these witnesses, he had given a report that he has done 3 tests to come to conclusion that this bullet is fired from this gun. And I was asking questions to him and he was giving more and more detailed answers. Now look, I was prepared, I was fully prepared here, okay, but he was giving the answer which was damaging, and I was realizing that if he had the photographs, how he has done, he had entire detail written in his worksheet, how he's conducted this examination to come to this conclusion that bullet was fired from the gun. And eventually, like, since I was getting all wrong answers, and I was totally I was not good on my feet basically that day. I realized that it is best to ask for time, and I took time, And then I went to my senior, Jose Peter D'Souza, and I told him, this is what happened today. We were prepared, but I cannot penetrate because whenever I ask a single question, he's giving 10 or multiple answers to it, and which are supporting the prosecution case. So he said that, what are your points? So I said, for this particular purpose, for this bullet to fire from this gun, you require certain things which are important. So he said, simple, don't ask him anything. Ask him what is important. Whether, suppose if a bullet travels from a pipe, then the bullet will have some scratch mark which belongs to pipe because it has traveled, especially in the case of katta, because especially it has gone travel from there in that this pipe. So you ask him that, is this marks important? But this was not there in the report which you had given to the court. Is this important? And similar type of question. So next day we went to court and we only asked this. We when we I went there, I remember I told this witness, sir, I made a lot of research on you yesterday since you were giving so good answers yesterday, and it was very difficult for me to cross examination to you, and whatever you say is absolutely right. I googled your name and so many papers have come on your name, and I know you are literally authority on this subject. Little gave him flowered him kind of thing, and then ask him, sir, is this important? Is this mark when the bullet travels from this gun, is this mark important? And similar question like this, what is important? And then I concluded my cross examination. So once this is done, my argument in the case was that if the expert says that all this aspect was important, why it is not there in his report? And only on this basis we were able to secure the acquittal, because there was no link except if we had removed this link, bullet and the gun. There was no other link to establish between that gun and that, and we got acquittal. Why I want to raise this, basically, I sure definitely there'll be many juniors who must be watching this webinar. Remember one thing, Google is not the answer to everything. Google may not give you everything. For other things, you have your seniors. You have to approach your senior wherever you have worked under them. Go back to them, even if you have a independent practice. Go back to them. You say that I have a difficulty, and this is my difficulty, and I can you address it? And even you can discuss with other, definitely, but your seniors will always help you. And remember, the advice given by seniors will be a great advice, and you will remember that for your life. Like as I said, like I remember this was a long time back this case happened, but I remember what my uh, senior told me. I think so. Yeah, it is 5:40. So here today I have covered most of the topics and the case relating basically the whole search and seizure. I would like to thank Sir Amol Sawant. I would like to thank Mr. Sangram Desai. I would like to thank Abhay Chiklekar and all other members who gave me this opportunity to conduct this webinar and speak on this topic. I also like to thank all the members of Bar Association of Goa and Maharashtra. It was a pleasure. It was a pleasure, obviously, to be with you for this seminar. Thank you. Thank you very much. I'm willing to take some. I saw
Yeah.
some chat. I'll be willing to take some question if any.
Yes, yes, yes. Thanks, Raju.
Yes,
You
Sri.
really, it's a great time to hear you, and you really illustrate all the provisions of this act, and with that too with your experiences. I know that Sindhudurga experience, and for the second time when you was willing to take that chance, second chance, that time I told them to take that precaution.
Absolutely.
Okay, so we'll continue with the questionnaire. Mr. Advocate Amol Kavitkar has asked a question: to whom the information of arrest and seizure is to be reported any time for frame or such or same relating
Yes.
to whom the information.
Yes. See, there are two provisions. One is basically section 42, subsection 2. It says that to the immediate superior officer. Suppose the information is received by um, PSI, he can give it to, because the word immediate is used. So his immediate superior will be the circle inspector or PI. If
Yes,
a PI receives the information, it has to be given within 78 hours to the device P, the immediate superior officer. So and depends upon whoever receives his immediate superior officer would receive the information. There's also another provision, but which is not respect to section 70 and information, but it is respect to section 50. If raid is conducted under clause 5, then this information has to be given within 48 hours to the immediate superior officers.
yeah. And same Mr. Amol Kavitkar has asked, please elaborate the power of seizure and arrest in public place under NDPS.
Yeah, I missed that, Mr. Amul.
Yes,
Yeah, basically, it is under 43 of NDPS Act. The in public places, any officer empowered under Section 42 can conduct search, seizure, arrest, attach the property, attach the document in the public places. And if you read 43 of the NDPS Act, it also gives you what is public place. A hotel is considered a public place. A shop is considered as a public place. So these are the public places envisaged under 43, but it also says that any place which is used by the public, usage of the place by public will be considered as a public place.
yes. Mr. Amit has asked, time limit to file retraction
As soon as possible.
as soon as possible.
As soon
Yeah,
as possible,
yeah,
because if you are coming immediately before the judge, then it has more veracity, it has more weight. Suppose, remember, you wait for 6 months. Imagine in these 6 months how many times he has met his friends, how many times he has met his family members, how many times he has produced before the magistrate. So the PP or the prosecution will always argue, look, he has been produced before magistrate. Not even this, in this 6 months time, single time he made a complaint. Only when he engaged a lawyer, now he is making a complaint against me.
yeah, yeah,
Therefore, as soon as possible.
yeah, yeah, yeah. Now, Mr. Bhanushali has asked how to approach the magistrate that you referred in your this lecture. How to approach the magistrate when police officers are not cooperating and under which section and what type of application.
Yeah. Now, look, definitely there's no format. Now, you
Yeah,
remember, if you look at the provisions of CRPC under 40, under 40 to 60, 70 to 81, 100, 193, I don't remember, 165. All these provisions deals with search, seizure, arrest, and warrant in different chapters. Now you will get one of these provisions. Like for example, I will give you, when accused is arrested, immediately he has to be told why he is arrested, and he should be given an opportunity to inform to his family members or a friend or a lawyer of his choice. Now, these are the provisions. You will have to go under this kind of provisions before a magistrate. In Goa, what happens is Goa, we are allowed to approach the magistrate even after working hours. Even in the night time, we can go before magistrate and file an application. I really do not know how it works in the other parts of India. It is
Yes,
difficult because I've been to
yes,
Rajasthan, even Kumta. I've been to Kumta and the other places. It is extremely difficult. But the moment next day a court start, you approach the
yes,
magistrate with the application
yes.
with this.
Goa is very liberal.
Yes, Goa is
Same,
liberal. It is
yes,
different.
yes.
Different. Yes.
Mr. Bhanushali has asked that which are the technical grounds which vitiates NDPS trial.
42 50.
Okay, okay, okay. And whether anticipatory is possible in NDPS? Uh,
Of course. Of course, anticipatory
yes,
bail is possible. You'll have to file it under 438 of CRPC again, claiming whatever your defenses are, whatever they are saying. But
that
anticipatory,
means
yes, possible.
you must be lucky enough to file that.
Yeah,
Yes.
you're supposed to be
Can,
lucky enough to file that.
yes.
I will. On this
Can
anticipatory, I remember one case. What
uh,
happened was one accused was picked up, and they were after the raid. Basically, just pick him up and take him, and then they were supposed to go to police station and conduct and show the raid on him. So he jumps from the police vehicle. He runs. He comes, approaches straight to me and says that look, they arrested me, they were taking me and they were supposed to file a case against me. So I file a anticipatory bail immediately to see this is thing that nothing was found on me and they were taking me and they were supposed to fabricate a case and put me under NDPS Act. So moment I filed the bail application, a reply came, the police said that we never arrested him. So because they
yes,
cannot, in order to conduct NDPS search and seizure, they'll have to follow all the procedures which are laid down under NDPS law. So they could not admit that they were taking him.
yes. Uh, uh, Advocate Vannamala has asked when accused is charged with commercial quantity, how
Yes,
to deal with it while filing bail application and in citation if any.
yes. See, I took this up actually earlier when a person is, as I said, when a person is arrested with a commercial quantity, it is a difficult job because you'll have to satisfy to the court at reasonable grounds to believe that accused is not guilty of a possession of a commercial quantity. Now, reasonable ground means that more than prima facie ground. So, if you want to show that, you see if there is compliance of section 50, you see if there is compliance of section 42. If it's not there, you can claim the bail on this ground. Or if you have a very solid proof, like I gave an example of logbook, that register which is used by the police for giving tea, or station diary. So if you could get this, definitely it's a good ground. Or even if you have an alibi, they say that you are somewhere else when they claim that raid is conducted. But if you want, in the modern days, I will tell you what you should do. If possible for you, remember a raid will be conducted in particular place. Visit the scene of offense, check if there is any CCTV footage around, track down the movement of the police from the police station to the spot and back, because they will come in particular vehicle. If any CCTV showing at particular point of time their entry on a spot, this is one way to show that they may not be on the spot from particular time to particular time to conduct the entire raid. One. Second thing is, today, everybody has a phone. Even accused will also have a phone. The raiding party member also will have a phone. If you are able to get a phone call records by using a private detectives kind of investigation, then get it and use it to show that look, the tower location of these phones are somewhere else when they claim that raid was conducted between this time to this time. And eventually it all depends of facts of each case. uh, so if you are able to show, As I said, also I gave that example of room number, a different room number of the
Yeah.
accused. That raid was
Yes.
conducted in one room, but he had booked another room. And similar type
Yes.
of case also we had in a Kota, Rajasthan. Same exactly. Room was different, but that was a relating. I will. This is also interesting. I will give her this. What happened was a raid was. Information was that two accused was supposed to travel in a train at 9 o'clock. So police goes and raids this one accused wherein the drugs were found under his berth. But there are two berths reserved, or two tickets are reserved in that train for one Mr. X and Mr. Y. So Y get arrested. X did not get arrested. Since we were defending this X, eventually when the charge sheet came, we realized that the timing of the train was 9 o'clock. The train was supposed to leave. The hotel register where these foreigners were staying in Rajasthan showed that this X had checked out at 10 o'clock. So there is no link between the drugs and the accused. So this is what is a prima facie ground. So you could even get a bail like this. You can acquittal also on this. But these are the things which you'll have to look in your charge sheet or a complaint.
Yeah. 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 One more question. That you drops are using young college boys in Mumbai really consist substance in drops. How it calculate and what are the chances of bail?
This is a very interesting this query actually. Now,
Yeah.
uh, I think so. You're talking about LSD mostly. Now, this LSD is, if it is LSD, there are other
Yes.
liquid form drugs also, but LSD is found in crystal form and also in a liquid form, and it is used. Even ketamine is used. Methamphetamine also is used in a liquid form. How do you calculate? See, uh, the original act, that is Act of 1985, gave the quantities. It does not say anywhere actual drug content. It is quantities which are given, small quantity and commercial quantity. But somewhere in 2007 and 2008, there is a judgment called E. Michael Raj or OZEF from Kerala High Court. The appeal went to Supreme Court, and Supreme Court held that only the actual drug content in the drugs should be taken for purpose of giving a sentence to the accused. Only the, suppose example, let's say you have 1 gram of cocaine, you mix it with 100 grams of sugar, so the weight will be 101. So the judgment of E. Michael Raj said that you can convict a person only for 1 gram and not for 100 gram. Now, this job has to be conducted by the chemical analyst. Chemical analyst can find by doing something called quantitative analysis of the substance. For that purpose, they will require a standard sample, and then they can say, all right, based on that standard sample, I come to conclusion that this is the amount of the drug content in this bottle. But once this judgment E. Michael Raj came on 18 November 2009, government came up with a notification to defeat E. Michael Raj judgment, to say that, and they introduced something word called mixture. So now, by that notification, entire mixture has to be considered, was considered to be a commercial quantity, whatever. And then there were a lot of argument and debate on this, right, which was from 2011. And in the Hira Singh judgment of Punjab High Court said again, no, uh, this notification is not good enough. And there was, or good enough, but there was challenge to this notification in Supreme Court before Supreme Court in Hira Singh judgment. The two judges could not give any opinion because E. Michael Raj also was a judgment passed by two judges. So they referred this issue to larger bench, and larger bench now has held that no, the word mixture is there. In order to calculate the drug content today, you consider everything. You consider the mixture as well as the drug content. So as of today, law stands that if you are found with possession of 100 grams of a sugar and 1 grams of cocaine, you will be charged for commercial quantity of drug, that is 101. So I believe that this has to be relooked, and to all this respect to the judgment and judges their opinion. But I feel they will. So there is a lot of debate. If you go on YouTube and you go on Google, you will find a lot of debate on this issue happening, and they may challenge this before the larger bench.
Yeah.
But
Thanks,
as of
Raju.
now,
There.
as of today, you need to look at a harassing judgment to come to conclusion. So mixture is the drug today.
Yeah. Thanks. We are receiving so many queries, but time because of time limit, we'll have to stop over here. And
They can, Mr.
one,
Savan, if they want, you
yes,
can pass on my number to them. They can call me.
yes, yes,
If
yes,
there's a query,
yes, yes, yes.
I can
They
answer.
all are in our group, so we'll pass them your number. And one chat said that this is a very meticulous lecture. So it is meticulously done.
Thanks a lot.
It's really knowledge all the juniors and the one who wants to practice in NDPS. They all have got really good knowledge. So with this, I take your leave and thanks to you on behalf of all the members of Sindhudurga, that Maharashtra, all the members of this webinar, and we'll stop here. Thank you.
Thanks.